Hello, good morning, good evening, wherever you are. Welcome to my conversations with Rudy Rivera. Today I am thrilled to have Jorge Ojeda, who is a partner at CCN. The name's very complicated, too complicated to say, but Cachos, Cavalos, and Newton. You divide your time between Monterrey and and San Antonio and Mexico City.
That's correct.
Thank you. Uh, Jorge, our topic tonight is the erosion of the attorney-client privilege in Mexico. And you and I began talking about this because of a change in the competition law in Mexico. Can you tell us what the Mexico competition law is and how it's affected the attorney-client privilege?
Yeah, thank you, Rudy, and it's a big honor to be here with you, with my friend Rudy, but moreover in this particular space. Uh, the last July 16, the Mexican competition law, that you can name it whatever, different countries, antitrust or whatever, the Mexican competition law received an amendment among which uh, an Article 77 bis was added to the law that establishes that those communications between the company and in-house counsels that are employees of the company are not subject to attorney-client privilege. So that means that when the antitrust commission, now the new commission is called antitrust commission, before it was a competition commission, if they do or carry out an investigation and they take all the communications from a company, the defendant of the company has the right to inform a unit of the Antitrust Commission which communications and justification to exclude from the investigation. Those communications that should be excluded are those between the company and their attorneys. However, they just amended the law to add that only with external attorneys will be subject to protection. So those communications in the company with the in-house counsel are not subject to protection in accordance with the amendment to the law. So that's the big change.
Well, but it's clear, though, that the attorney-client privilege with regard to outside counsel still exists.
Absolutely, but that's an unequal situation for in-house counsels. An attorney should be understood not in the dimension of as an employee, but as it functions. An attorney has the right and a duty with respect to the professional secret. It's a right for the client, it's a right for the attorney, but it's also a duty for the attorney and a duty from the authorities to protect and defend and to keep protected the attorney-client privilege. That is a direct meaning of a law and the right of the people to receive counsel and protection under the law. And it's not only in Mexico, that is in the Constitution and is in the Human Rights Convention of America. So, and this is very common. Now, the Constitution doesn't distinguish between in house counsel or external counsel. Before this amendment to the law, there was no distinguish or distinction between in-house counsel or external counsel. So this is something that could be seen in two ways, as the way this affects an in-house counsel, and in a way it affects its employer, that at the end of the day, it's its client, if you see it in a broad way. So this is a serious change and a serious threat to the attorney-client privilege, in my opinion.
Well, but it creates a problem for the inside counsel, right? Because now his communications are not going to be uh, guarded under the attorney-client privilege, right?
That's exactly right.
Hmm.
That's exactly the point, Rudy. If you are an in-house counsel and as you know, many companies, and the fact that you are an employee doesn't mean that it changed the function of the nature of the profession of the attorneys. So that's not an excuse to exclude the professional secrecy because you are an employee of a company. The nature
Right.
of the attorney position in anything is that you provide counsel to your client or to your company, and that is precisely why attorneys leave. Let's put a simple example. It's like saying
Okay.
that the psychology is not obligated to keep secrecy if they are if they are uh, a company psychologist, and they provide, advice to employees companies from the company. Well, the nature of the person is that they have to keep professional secrecy, is part of the nature of the profession. And that is protected
Correct.
by Article 16 and 20 of the Mexican Constitution in the way that a defendant is entitled to keep full confidentiality and protection on communications with its attorneys. And that's
But
the base for this interpretation in all other areas.
well, now is the passing of this law coincide with the Constitution?
Not in my opinion. Not in my opinion. It's tough. As everybody knows, in this moment, Mexico is living a situation where there's a ruling party very strong, and they can modify all type of level of laws, even the Constitution, easily. But in my opinion, it's completely impossible to consider that this right is compatible. The Mexican Constitution contains a rule that the professional secret may be broken by court order. But even that, in those cases, the communications between a defendant and its counsel are unbreakable. Okay, even with a court order, because that is considered to be a basis for its defense. If you consider that right without exceptions in this particular case, and the broad interpretation that has been in general terms in the right to defend, there's no exception in our opinion, and it's incompatible, this amendment to the competition law, with the Constitution.
Well, it's similar to Mexico's enacted, similar to Europe. For example, in Europe, inside the communications of inside counsel are not privileged because there's a lack of independence.
Well, I understand that that's the way many countries in Europe actually we work together. Rudy, you know exactly where I'm referring. I cannot give many details in a case where this was analyzed, and with the support of ACC. Well, ACC provided an analysis on conflict of law and different laws in Europe, and it's not a general rule. And the tendency of the countries is in the direction to protect the in-house counsel's secrecy and professional secret rather than going in the opposite way.
Hmm?
So that's a big change. It's a living aspect in the law.
Well, I think that if you have the attorney-client privilege, okay, and from a U.S. point of view, it should be respected no matter what your position is. Now, there are some instances in certain types of investigations where they're not protected, but for the most part, it is a sacrosanct right. Now, in the U.S., sometimes you have a situation where the attorney-client privilege, you want belts and suspenders, so you still hire outside counsel.
Mm-hmm.
To say you have the attorney-client privilege internally, but you still want outside counsel, just what they call belts and suspenders. Okay.
Okay.
But now in Mexico, it seems like you're always going to have attorney-client.
Well, this is let's call it, this is a new element in Mexican law.
Mhm.
We need to see how things develop. Let me give you a little background on some aspects, Rudy.
Sure.
There is a court precedent, it's a thesis, it's not a jurisprudence, in the sense that the communications between a client and an attorney are subject to full protection unless there is a justification based on the involvement in a crime from the attorney. So if the attorney actively or is working in something that could be illegal, that may be a way to break those communications. This has not been a mandatory court precedent, so it's only a criteria. In general terms, the protection in Mexico being absolute, and it has a reason to be that way. Of course, I can understand some contradictions, but contradictions could be understood that there could be one way or the other. The main aspect is going to be how, on this situation, when the court analyze this aspect, whether or not Article 77 of the competition law is considered unconstitutional or not, that is going to be the moment of truth. But let's put it this way. If you break this situation, you are putting in an unequal condition an in-house counsel with respect to an external counsel. Second aspect, if you do not have a good quality compliance and protection of information in your company, mistakes on how you use the consultation of external counsel may be implied or may be subject to internal communications that may be broken with this criteria. So this is a very weak situation. Now, this is not the first time that the competition authority tried to break the professional secret. In the past, there was, I think it was 2017, there was a regulation to the competition law pretending to break the professional secret of in-house counsel. There was a consultation on those rules. Mexican Bar Association participated actively and explained the big concern and lack of justification to separate this type of situation, in-house versus outside counsel. In that time, it was resolved in favor of the equality between the in-house counsel and external counsel. However, now they move in the opposite direction, but they didn't stay just in a regulation. They sent it to a law. But even this is contained in a law is still, in my opinion, unconstitutional. Now, this will imply a different discussion on how to protect the right, because also the amparo, as you know, is the Mexican habeas
For
corpus.
people who don't know Mexican law, what's an amparo?
Is the constitutional review of those acts of authority. In the U.S., it's like it's a weird combination of an habeas corpus and how you call it, I'm sorry, relief.
Okay, but do you think that why do you think the government did this? Why did they decide they wanted to eliminate the attorney-client privilege?
Well, first of all, if they carry out an investigation, they want to, and they take the information from the company, they are trying to take that information, of course, to use it against, the economic agent that is involved in an investigation case, in an antitrust investigation. Now, the bad thing, and this being the experience from other firms, is that technically speaking, when they take your disk of all your communications, there is a section from the competition authority that reviews this, and you have the opportunity as economic agent with your lawyers to identify those communications that they need to exclude from the investigation because are subject to attorney-client privilege. Okay. So what is the problem? The problem is that if you have that opportunity, but in the past, what has happened is that technically those communications should be excluded, and then the case goes to the other area of the Antitrust Commission, where they take the information, of course, that was considered to be valid, and they can review, investigate, and rule accordingly. What has happened in the past is that even the communications excluded clearly been taken into consideration. So there's a big doubt on how these communications being really protected. So that's the first questioning behind. The second aspect that you can mention here is whether or not, if that communication been already disclosed, you can exclude it. Then, of course, you will have your defense opportunity and you will be able to exclude, but anyway, will be known what was that communication. So that is already a harm to a company, that a communication that could imply a damage for the company or a consultation could be taken against the company. So what is their intention? Clearly breaking that attorney-client privilege and using
Because they feel they'll get more information to prosecute companies or fine companies if they can get those communications.
That's exactly right.
I mean, the reason why the attorney-client privilege is almost like one of the Ten Commandments is because, your priest, your rabbi, you're supposed to be honest completely, and a lawyer cannot represent you unless he knows everything.
Well, and not only that, Rudy, even if a person or a company committed the worst crime in life, they are entitled to a defense. That's one of the minimum rights, and a human right, a basic right that has to be protected. And if you see court precedents, and for those that are not lawyers, you can see, for example, the movie from Tom Hanks, I strongly recommend it, that where is the breach of spies. You can see I forgot the name of the
Bridge of
Name of a
Spies.
Bird and other movies like that. For those people that are not lawyers, you can see that being a lawyer is normally could be not popular because you maybe end up defending a company that did wrong, or a person who did bad. But anyway, those people are entitled to receive a fair trial and to receive a fair judgment for whatever happens. Otherwise, you will be falling into you can help me with this word, linchamiento. So basically, they will be using everything against you to kill you and smash you in the floor.
Yeah, they will use it, so they will force you to self-incriminate yourself.
Absolutely.
Yes.
Absolutely. At the end of the day.
We do have a question. Does this reform to the competition law violate the commitments Mexico made under the USMCA?
I don't think so. I don't think it's subject to that. Actually,
What is USMCA?
I'm sorry?
What is the USMCA?
Okay, the USMCA is the trade agreement between Mexico, US, and Canada. And certainly Mexico has commitments to have an anti-competition compliance. The grandfather from the existing treaty is the NAS is the former agreement. This in the When Mexico entered into that agreement, there were many requirements from the U.S. To make NAFTA. I'm sorry, I forgot the word. There were many requirements imposed to or requested to Mexico. One of those requirements was to have a real independent judicial system, which was the cause of the amendment to the Constitution and the reform to the Supreme Court in 1994. Also, Mexico had the commitment to improve environmental compliance. And of course, the environmental competition and the competition was part of the requirements to Mexico. But the fact of having this amendment to the law is, in my opinion, different from that commitment. This could be a useful or not useful tool for the authority, but is different from the commitment to have competition, good competition commission.
Well, how would then walk me through what a Mexican company would do when when all of a sudden the government's coming in and they start to investigate?
Well, if you are a company that are exposed to an investigation from the competition authorities, and the authority goes and starts an investigation against you, and you have done nothing in advance in compliance to be prepared, in my opinion, you are a little bit too late already. Okay, so let's call that step number one. We can revisit this concept afterwards. But what is going to happen is that the authorities are going to arrive to your domicile. They are going to be taking your communications, your hard disk. They are entitled to do that. And then you have the right to go in that stage before it goes to the commissioners. You have the opportunity to request the authority to exclude communications to that area that segregates and review the information and determine which information should be considered for the investigation, to exclude the communication so that the authority is going to review whether or not your conducts are or fit into the condition to affect or trust conditions, or you were basically doing wrong as an agent. That is the moment you have the opportunity to exclude the communications. If a communication is being taken and wrongly taken and considered, you may go with the authority and with the procedure with the court to request, once the resolution is issued or in different stages, to different remedies to try to avoid that is considered. But anyway, once it's released, the communication, that is a big harm already for the companies.
But is this law retroactive?
No.
And so the problem you have is you have all these communications prior to the enactment of the law that are now subject to disclosure to the government.
Technically, the communication, this article cannot be taken retroactively.
Well, that was my question. So
Yeah.
communications prior to the law being enacted, are they still privileged with Insight Counsel?
I consider they are.
Okay.
Now let's see what the court says, because it's going to be part of the discussions. But if there is no reasoning behind, because that would be a breach to the Constitution as well, to apply retroactively an article that was included in July 16 to the law.
Your opinion is that this law is prospective. It will apply to all future communications with in-house counsel.
Yes.
From the date of the act moving forward.
Exactly. But now you need to go to what is going to happen with the defense. Now, the big point here is that, let me go a little bit on the amparo we were discussing. When you go to, if you go to a court at this moment in Mexico, we used to have very good opportunities to declare unconstitutionality of laws that could have general effects for everybody. So it was like basically similar to the US. A court can determine that certain articles of a law are not constitutional, and consider that those should not be applicable to everybody in universal condition, in general terms.
Well, you're talking about the judicial reform, which basically limited amparos. And so you now don't have the same vehicle in which to challenge this.
Exactly.
Because the constitutional challenges, basically, well, the ability to make constitutional challenges has been watered down.
Well, it's not completely watered down, but if you, in this case, what we call unconstitutional action can only be promoted by very limited, states, the certain number of representatives, very specific cases. And there's one that should be, in my opinion, a very clear one, is those that are requested by the National Human Rights Commission. But they are not going to do it. They are not fully independent now in Mexico. So that gives you the opportunity to defend yourself as a person, as an individual. So you can defend yourself either as a company having this situation, or as an individual lawyer that you are an in-house counsel on this unequal condition with respect to the external counsel. The problem is that if you there are two different moments where you can defend yourself, or you can defend this aspect. Is right now that the law just was issued, and the other moment is once the law is applied. So let me put the distinction. This law is already a law, it's effective, and in my opinion, it's already affecting the legal profession for those in-house counsel. So you have the opportunity to already start an amparo lawsuit at this moment. The other opportunity is once the company is subject to an investigation procedure, you can file an amparo lawsuit in that moment. Now, the point is that until this is resolved in a definitive case and creates a definitive court precedent called jurisprudence in Mexico, this will be in the air. So what will be the best way to defend or to protect in-house counsels and companies? There are three things to do, in my opinion. First aspect, it would be great to see the work organized from in-house counsels and companies to start defense against these resolutions with the intention to create a court precedent that is mandatory for courts and for all authorities. Because court precedents in Mexico only benefits to those that receive the benefit of the resolution. So it's not for the benefit of everybody until it turns to be court precedent definitive as a jurisprudence.
Well, what you're saying is that it's not binding. So a court decision in one case is not binding on another judge.
Until it is a jurisprudence. What I'm saying is a court precedent only benefits to the person who received the benefit of that court precedent.
And not everybody, not a national order, like a national injunction people complained about in the United States.
Exactly. That is the principle that the amparo resolutions are not protective erga omnes to everybody. So that principle, Mexico read out of that principle for almost 30 years. And now that principle came back to the Constitution. So the way to defend this for companies and in-house counsels, again, there are two opportunities, but it would be great to see in-house counsels and companies working to create as soon as possible these precedents to be mandatory.
Now, Jorge, because this law has passed, all inside counsel in Mexico, and even U.S. counsel to companies that have Mexican subsidiaries, have to really reformat or change the method in which they communicate on sensitive issues.
Absolutely. So that's the third aspect or the third opportunity, and is what can you do internally as a company to defend yourself and to protect? Well, preventive medicine is the best medicine that I recommend to clients, and this is one of those cases. If you are going to give consultation on things that could create any type of situation, you need to be careful that those communications are with external counsels and with protection, because otherwise you don't want to be involved in a dispute whether or not this is protected because you use your in-house counsel. So if I were a company, I will be using a system of communicating. It could be the in-house counsel communicating with external counsel, but I will limit communication with external counsel with external counsel, or director with external counsel, but will avoid communication inside the company with internal counsel.
Well, you have to have a program within the company to spot these issues, because obviously not every communication is going to subject the company to liability. Okay.
Absolutely.
But it has to be a situation where in-house counsel in Mexico, or even the CEO and some of the C-level executives, have to be able to identify certain risk situations that involve a risk to the company. So at that point, you get inside counsel involved, and if he or she sees, well, the company may have some liability or some exposure here, either civilly or criminally, then at that point, that counsel needs to get outside counsel to basically be the leader in this thing, even though, or if not the leader, it's to be the buffer.
Exactly right.
The buffer, because to me, the in-house counsel is the one that really needs to do the investigation. He knows the business. She knows the business. You bring some outside counsel in that doesn't know your business, then you're talking about an unnecessary expense. but I think that's important. And then the team needs to be trained to, when they communicate on this matter, to copy not just you, but to copy the outside counsel.
That's a very good point. But in any way, Rudy, in any of these situations, you have two options: defend yourself afterwards or get prepared in advance. Always, if you get prepared in advance, your situation will be stronger. So I fully agree with you.
Yeah, I think it's better because sometimes you have people disclose things, and I've seen this before in situations that in their mind was innocent, but when you look at it in an email, it could be very compromising,
Absolutely.
even to the point of some type of admission. Like, for example, some employee says, "Hey, what's going on with this?" And the other person replies, "Ah, I did it. Okay, so what?"
No,
Now,
yeah,
it may sound like a
or
joke, but then in the email, it may not be a joke.
absolutely, or hey, let's go and talk with our competition what they are doing, and maybe you're joking, but yeah, but it's already there.
Well, we have a question. Has the Mexico chapter of the ACC already made a statement on this matter? The ACC Advocacy Committee is looking into it, seeing what can be done. ACC filed an amicus brief on another matter where the attorney-client privilege was being compromised. So yeah, the ACC is very active, and ACC is also active throughout the United States and Europe, actually anywhere in the world where the attorney-client privilege is challenged in some form or another. The ACC always tries to intervene either in the form of an amicus brief or working with some people lobbying. But yeah, it's something that's it's a high priority for the ACC's advocacy committee.
I fully agree with you, Rudy, and we've been in communication with ACC, as you know, and it's also Mexican Bar Association is trying to is on discussions with ACC to also supporting this cause.
And,
This is a
and,
common cause for all advocacy.
and your firm has provided actually some free legal work for ACC to assist in this matter. So we're grateful for that. ACC is very grateful for that.
Thank you, Rudy. It's our pleasure, and we consider a duty to support.
So if now that you want to implement this system, how would you recommend, like if I come to you as inside counsel, Jorge, this law is making me crazy.
Mhm.
I don't want my company to have issues down the road. What would you recommend I do right now?
Well, you should consider filing an amparo lawsuit. But let me explain this situation very interesting. Nobody knows how this is going to be interpreted. The Keep in mind that beginning on September 1st, there's going to be a complete new composition of the Mexican Supreme Court. That's the new court voted by the wise people of Mexico. I'm just kidding on that concept, but that's the way they mention. But basically, it's a court being elected by the people. And almost all courts, all federal courts are either already transitioned or are in the process to be transitioned to this system. So what I'm trying to tell you with this is that nobody knows how the new court is going to be ruled, how independent the court is going to be, which is one of the big concerns of this judicial reform. I'm sure that you have talked already on this topic with other people in your program, I remember.
Well, I get it. I get it that no one knows. Well, that's a separate topic. What this court's going to do on any issue, not just the attorney-client privilege.
That's exactly right.
In
But
the meantime, yeah, I'm going to you and say, well, assuming I get a judge that it's going to be smart, not one of these other types of judges, let's say, that are more politically inclined, what processes could I put in place?
well, definitely you,
Help me.
you should consider promoting an amparo lawsuit at this moment. The situation is that if the amparo lawsuit is resolved to protect the company, then the company will be protected either if they change of counsel. But this this amparo lawsuit, in my opinion, should be considered to be, filed by the company and also by in-house counsels. So a common action from companies and in-house counsels intended for this to be finally resolved and create a court precedent that if in the future a company that is not protected by those resolutions is subject to an investigation could have a mandatory court precedent jurisprudence that could be used as a defense.
Yeah, but I think when your suggestion to file an amparo is after the government comes in and wants this information.
Oh no, you can do it right now.
I can do it right now.
Yeah,
Well,
you have two opportunities to file the amparo lawsuit. It's 30 business days after the law was published and started to be valid. That happened since it was published in July 16. Or you can wait for what we call the first act of authority that you want to defend. So that will be when you have an investigation.
yeah, but Jorge, I would be reluctant to file, for lack of a better word, a preventative amparo, because at least now I'm on their radar. If I lose the amparo, I've already given myself publicity, let's say, and that may cause an investigation. So short of filing an amparo, a preventative amparo, and I say to you, yeah, Jorge, that's a great idea, but I don't think I want to do that now. Our CEO doesn't want to file anything in court yet, especially with the uncertainty of the of how laws are going to be interpreted. Because the downside I see to filing it is the court says, oh, you got to disclose everything. Now I've got a judgment saying I have to disclose everything.
Well, that may happen, Rudy, but let's imagine that happens with this amparo wave, let's call the wave of this number of new amparos. But then you know exactly the rule of the game. What is terrible is to be uncertain what's going to be the rule of the game, or assume that the rule of the game is the worst case scenario and get prepared for that.
But I would think, and this is where I would differ with you a little bit, is the first thing I want to do is say, what processes do I implement so I can minimize this? Okay. What would you recommend? Should I educate my employees? Should I then have written policies and procedures on how we deal with even the slightest hint of litigation or the slightest hint of a government investigation? Give me some policies that I can implement and I can try. And at the very least, if the government comes knocking on my door, I've got those systems in place that can minimize a lot of the risk without the necessity of filing an amparo.
Well, I fully agree, but let's put it this way. That preventive action, in my opinion, is compliance, and all that is compliance and preventive actions in this, I will do it right away. But you don't need to wait for this. All companies that are, let's say, companies that has certain risk, you need to identify those risks and exposures that you have as a business, and you need to implement preventive measures always. That's I fully agree with you. Now, the situation that I see, and you're right, is if that gives you some exposure that you are afraid to lose your, let's say, that you're afraid for a competition investigation. Well, not necessarily. You should have a company that is at risk to do this work. Again, if companies gets organized, most of the business are not in the radar and do not imply any risk whatsoever for competition law. But maybe those companies in the common interest to have this protection could cooperate different than those companies that could have concerns. I don't know if I explain myself clear on this, but I think it's a question of getting organized as companies and in-house counsels to get to a certain level of protection or lack of protection, but at least be clear on what's coming here. Another option, let's call it another option, is do nothing in this moment. See how things move, get prepared for the worst, and maybe in the future, the court that we think is not going to be a fully independent court may turn to be very court that everybody expects. I have my doubts that is going to happen, but assuming that happens, that this court really works in the direction it should and works independently, maybe your rights will not be unprotected the way we expect, and you will not be afraid of that. So you have several options. The first one, and I fully agree with you, is train everybody, make sure that people understand the compliance, and moreover, if you are a dominant company in your relevant market, you should be very careful and have this in your compliance, and not one time every 3 or 5 years. This probably should be something that you want to reinforce, and train people very clear since the beginning, and keep training every few months or once every year at least.
I believe every company in Mexico should do a health check. Just like you go to the doctor to see
Yes.
what's wrong with you.
Yes.
I think companies should look in and see what potential exposure do they have on any given issue. At that point,
Absolutely.
huh?
Absolutely. Well, you're a life example of that prevention.
Yeah, I am. I am. With my bypass surgery, I decided to fix something before it got broken.
Absolutely.
We have another question. Could you please repeat which article of the Federal Economic Competition Law states that communications between clients and in-house lawyers are excluded from the legal privilege?
Okay. Is the Article 77 bis of the amendment to the law that was published in July 16. So just 20 days ago.
Well, is the attorney-client privilege for in-house counsel? Well, let me rephrase this question. So the competition law says for violation of the competition law, inside counsel communications are no longer privileged, right?
Exactly. Only those with external counsels.
Well, what about for areas outside of, competition statute violations? Is the attorney-client privilege still there?
Yes, sir. Continues to be there, with few court precedents that are not friendly, but not mandatory precedents, only theses. But in general terms, the protection of the professional secret in Mexico remains fully in the Constitution. The Constitution doesn't talk about client company. They use all these situations in those cases where criminal law, but it's clearly interpreted everywhere that is the same right for those cases that are criminal law, civil law, administrative, etc. The protection is also established in the law that regulates professions in Mexico. That is the constitutional law of Article 5 of the Constitution, and also contained in many laws, civil code, civil procedure code, criminal procedure codes, among others, and also part of the analysis in private regulations, such as the Code of Ethics of the Mexican Bar Association.
So, do you see the attorney-client privilege eroding in other areas of Mexican law now that this exception has been carved out in the competition law?
Well, many things in life, Rudy, I think I said in the past that will never happen. But life has shown me that I'm not a wizard. I don't have a crystal ball to tell you what is going to happen or what is not going to happen. So my point is, if you have a government that does not have a fully independent judicial system, and they started with this one, and you say, well, I should not be concerned. I'm not in a company that is at risk to be subject to antitrust investigation. Well, if you do not consider this serious enough, then the day after they are going to go against other business because they saw that it worked. So at the end of the day, this, in my opinion, is hopefully this will stay only here, and it will be subject to a big discussion, and hopefully the court will determine that this is unconstitutional because it's clearly against the Constitution. Now, if the court rules in favor that this is legal, whether or not the authority will try to break other communications, I can tell you they will have the opportunity.
I would think that if I'm even if I'm a corporate in-house counsel for a corporation that's not likely to be involved in anti-competition violations, for example, it would still make me worried.
Absolutely.
And I would still try to implement programs, do the health check and then implement communications.
That's exactly the what I was referring, that this is not just a protection for the company. It's a protection for the counsel, a protection for the company. It's a protection for the sake of the nature of the counseling of a lawyer.
Right.
It's at the same time a right, it's at the same time a duty. So you when I when if I tell you that I feel a way of this concern because I'm an external counsel, I'm not. This is then the next law is going to say, well, why not also external counsel, because this is something that could be considered that a lawyer advising a client or giving advice in any way could be part of the crime or part of the administrative illegality that the company is doing by just being consulted. So then you become participant of the illegality. That's
Well, I would
completely,
think
what I'm saying is completely wrong. And everybody could say, you're saying a dumb thing. Well, we don't want that dumb thing to even be considered to be the next amendment to the law.
I would think that outside counsel would be very happy that this law is passing because that means you're going to have to hire outside counsel for every government investigation, every anti-competition investigation.
Well, in this moment, yes, but if they,
You have a big smile on your face when you say that.
well, the thing really is I'm trying to remember, but I don't want to seem silly with what I'm going to say. But there have been experiences in life where that you can take on these type of situations, and why this could be considered serious. I don't remember who wrote this, and please forgive me if my English is terrible on this situation, but there was this story about the Nazis where there was a person saying, "Oh, first they came for the Jewish, but because I was not Jewish, I was not concerned. Then they went against the Gypsies, but because I was not a Gypsy, I was not concerned." So they were going against everybody, and then at the end of these phrases, it says, "Well, now they come against me, and there's nobody to defend me."
Yeah,
So are
that
we as a profession, we're going to leave this away and feel that this doesn't matter because I'm an external counsel? Not in my case.
no, I think outside counsel should be worried also because I think the erosion begins there with the competition law, and it's easily expandable, especially with the new court reform, judicial reform. I think everyone should be afraid of everything, honestly, when it comes to the courts in Mexico.
Well, and this really could be, let's imagine that you go to a casino and you're willing to bet in one of those tables in the casinos. And you sit there, start betting with rules, and then all of a sudden, in the middle of the game, they decided to change the rules, but you're already there. So this is so basic in the importance, is so basic in the importance of the legal profession to protect the professional secret, that any attempt, either minimum or even without contact of your direct opportunities or what you do as a lawyer, in my opinion, is a harm for everybody in the legal profession.
I mean, I think your analogy is really good. I think eventually they're going to come for everybody. And, I've already seen in the time, I'm not a Mexican lawyer, but, I've dealt a lot with Mexican law. And what I have seen is somewhat an erosion. I've
That's
seen,
correct.
and of law in general, I've seen cases that you most likely would lose at the trial level, but because of the professionalism of the appeals courts and the constitutional courts, and you have some certainty that you're going to have judges, competent judges, career judges decide issues. Now you don't know who's going to decide a case, and you don't know what inexperienced person is going to be dealing with complicated constitutional issues. So that's a big scare right now. And now you have this, well, the attorney-client privilege isn't going to apply in competition cases. And then to your point, who knows what else is going to happen? Which to me, it's a serious, well, some companies may not care, but could be a serious impediment to investors coming in.
I fully agree. At the end of the day, the hope of people is that what is happening with the judicial system, to a certain extent, is going to be a callback. This is not working. Hopefully, that will be the case. I know, Rudy, I'm going away a little bit from the topic and going back to the judicial system, but there is another precedent in the world on a country that elected Supreme Court justices, and that's Bolivia. Bolivia elected justices, and what happened, all of them were resolving all cases favorable to Evo Morales. When Evo Morales was removed from power, the court, what do you think the court did?
What did they do?
In favor of the new president. And when the new president, they called elections and won the new president of somebody aligned with Evo Morales, guess what happened? Again, the justices ruled in favor of the then new president. So that is not an independent court. You don't want to be there. Electing the legal profession is not popular, Rudy. Being a judge is not popular. There's always a party that wins and feel that justice was good. There's always a party who loses and thinks that justice was unfair. Most of the times, unless you really know that you had no right to really claim and you were going to lose the case anyway. So if you have a real dispute, that's a little bit part of the game. Now, but not having career in the judicial system, not having a real independent justice is a big risk in any country in the world. So yeah, I fully agree with you that is not a nice situation in Mexico. However, hopefully, and I think sometimes I'm more optimistic that I seem, but I really expect that things are going to be hopefully controlled or improved based on the importance of Mexico to keep in the world and trading in the world, because otherwise we're going to be isolated over and over, little by little.
Well, the rule of law, since you touched on this judicial reform, some and I did too. I mean, the rule of law is important, I think, for any country to have an independent judiciary. One of the things President Sheinbaum said in her mañaneras in the morning that she's carried over from AMLO is that, well, in the United States, they elect judges. And yeah, well, they do, but not.
Yeah, well, it's very different.
Not in the federal system, number one. Number two, the judges who are elected are generally elected at the state court level.
Mm-hmm.
And in a number of them, a number of states are appointed. In a number of jurisdictions, they're elected. And in my opinion, that does lead to some problems because it's not a perfect system even in the United States. You have judges who may not be subject to corruption as they might be in Mexico, but you do have somewhat of a political influence because the judge has to, consider the voters because they have to run every so many years, right? But the big difference is that there's a bar that sanctions lawyers. There's a judicial ethics committee that can sanction judges. And there's none of that in Mexico. So that's the big downside. So where Sheinbaum says, oh, well, they're elected in the United States, but we have a lot of other controls that could prevent the judge from what I call going rogue.
Well, you're touching now something very sensitive. Keep in mind that I forgot to put my pin from the Mexican Bar Association. I have Mexican Bar Association in my heart. As you know, I've been very active there for a long, long, long time. I understand your point, but you have to have honorable members of a bar to create a good bar system. Mexican bar affiliation to a bar in Mexico is voluntary. Is you don't need a bar approval to basically to proceed with your legal profession. So in Mexico, when you there are many professional associations, but only few are really reputable. One of those is the Mexican Bar Association, in my opinion, the most reputable one and the largest in Mexico, and it's still very small. We have code of ethics, and the worst sanction that you can get in the Mexican Bar Association is, being dismissed from the Mexican Bar Association and send a resolution to Profesiones, which is the authority that regulates professions in Mexico, saying that in their opinion you should be considered to revoke your license. That's the worst thing you can ever get. But let me tell you something that could be more terrible. Mexican Bar Association is the only bar in Mexico that has ever sanctioned members, and many times. So being a member of the Mexican Bar Association is a compromise with the profession. Now, let's go to a different situation. Will I be willing to, should I agree to be Mexico turn into a mandatory bar affiliation? Well, who is going to be that bar? If that bar is going to have the influence from the government, I prefer not mandatory bar affiliation.
That's the problem, and I've said that before in other talks. I think one of the reason I believe that the lawyers don't want a mandatory bar is for that reason. If
That's
you're taking on a case that's unpopular, then you've got the Mexican government threatening to take your license away.
Let me put you an example, Rudy. I remember this story. We were defending a client that there were an authority that they did a tax audit to them. And basically, the auditor said, either you give me X money or I, I will rule this audit against you. Of course, my client and us, that we have zero corruption, we say, no way, we are not going to participate in any corruption. That's not an option. Well, what they did is they basically rejected all deductions of that company for an entire year and issue a tax credit that was huge, many, many, many million. In those occasions, I was the person available in that location, and I filed the demanda, the lawsuit against that tax credit. Well, I received a call from the authority, and I went because they called me for a meeting and say, well, you should consider paying, and if you prevail in the case, you will receive the payment back from the government, which is very tough in Mexico to get it. When I mentioned that was not an option, and they keep pushing and very aggressively, I said, well, I receive extortions in the avenue next to here, not inside here. We're in an authority location. What happened then after is I received a tax audit personally that I had to attend. So yeah, if you can see those type of situations in Mexico and you still are able to defend yourself, having the opportunity to have not a perfect judicial system, but let's say a reasonable independent judicial system is very scary if we go in the opposite direction. So hopefully the people will consider, hopefully our new justices and our new judges will understand that they are there to do their job, not to be popular. And another big difference in the U.S. and in Mexico, Yuri, you can talk about this, Rudy, is the function of a jury. A judge could be elected, but the jury determines whether or not the facts, correct?
Well, Jorge, my uncle, who was a lawyer in the Dominican Republic under Trujillo,
Mm.
was barred from practicing law. He was under house arrest. And the only way he could make money is to work as a paralegal, where lawyers would then work to him and they would sign and he would do it. And of course, Trujillo, died. He was assassinated. And um, then, of course, he got his license back and had a very lucrative career as a lawyer. But yes, it can happen. We have another comment. As incredible as it may seem when reviewing the website of La Cámara de Diputados, specifically looking for the current federal economic competition law, it states that the latest amendment was published on May 20th, 2021. This is despite the fact that if one checks the official gazette directly, the reform decree does appear.
Well, my suggestion is if sometimes that website may be not updated, but if it's very efficient actually. If you put Ley Federal de Competencia Económica, you will immediately see in the website, will open the website of the Cámara de Diputados, that's the House of Representatives. You click on the law, and I can assure you that the law already contains, it will say publish and last amendment, and it will reflect that one.
And that's Article 8, did you say?
No, it's Article 77 bis.
77 BIS.
Yeah, let me show you, by the way, because I think well, it's not there. It's very unusual. It used to be very efficient.
Mhm.
Wow. But if you go to Diario Oficial de la Federación, let me share with you my screen. Okay. I don't know if you can you see the screen?
I can see this, yes.
Okay, it says decreto.
Yes.
Okay, it's Ley Federal de Competencia Económica. Okay, here is the article.
Okay.
So this is the particular paragraph. So as you can see here, this third paragraph establishes that committee that determines whether or not those communications should be excluded to be, filtered. And the fourth paragraph that we've been discussing is actually this one.
That's good. Yeah, I remember reading this. So yes, I remember seeing it.
Yeah, I'm very, very surprised that the website of the Cámara de Diputados is not being updated. It used to be even in the same day. That's very sad to see that they are not doing that quality
Well,
they used to do.
as we say in some parts of the world, there's a new sheriff in town.
That's exactly right.
Well,
But this is honestly, this is very sad. I used to be very impressed to see that sometimes even the same day the law was published, you were able to review the law with the actual note that it was amended.
well, Jorge, at this time, I'd like to say thank you for taking the time. I know you're a very busy man. I appreciate you taking the time from your busy schedule, and thank you to the people who showed up today. If anyone has any final questions, before we sign off, just let me know. Put them in the chat. But with that, I think we're going to sign off. Thank you so much.
Thank you, Rudy, and thanks everybody. And I'm never busy for my friends, and thank you, Rudy, for everything.
You're welcome. Thank you.